welcome everyone to our next Recover webinar, Asbestos Litigation, Ongoing Challenges. We're very lucky to be joined by our two industrial disease partners, Euan and Guy this morning, as well as Dianne Foster from Asbestos Action. I will just let everyone know that this will be recorded. It is being recorded currently, and it will be distributed after the fact. We'll also share the slides from the presentation as well, if anyone would like to share that with colleagues or anyone else in your firm. If you do have any questions, please stick them in the Q&A box throughout, and we'll take them at the end. If something does come up pressing, I'm sure we can tackle it in the middle of the presentation as well. But just stick them in the Q&A box and we can get to them at the end. And yeah, I will pass over to Euan to lead us off.
That's great, Stuart. Thank you very much for the introduction. Yeah, so we thought it'd be helpful. We did a talk with this last year, myself and Gary, and just to give an update as to where we are with asbestos disease litigation, and give you an update as to the challenges that we are facing, the difficulties that these cases present. And it was also an opportunity for us to introduce you to the charity, one of the charities that we work alongside, which is Asbestos Action, who are based in Dundee. So Dianne, who is in charge of that charity, is here today to just give some background as to what they do in their charity and the great work they do for all the people diagnosed with asbestos-related diseases. A tiny bit of background in terms of Digby Brown, and our department that deals with asbestos disease has grown to 10 people. So there are 10 people in Digby Brown dealing exclusively with asbestos-related disease cases. We have a team of paralegals doing pre-litigation work, and then a team of solicitors who are dealing with the litigated work. So it's a big chunk of the work that we do here at Digby Brown. So I thought it'd be helpful for us to give a bit of background as to where asbestos is found, the conditions that we see, and then the legal challenges. So I'll pass you over to Gary, who is the other partner in the team, and he will give his explanations to the conditions themselves. Thanks.
Thank you. Morning, everyone. So I'll quickly recap on some basics quickly in terms of what is asbestos and the conditions, as you had mentioned. Apologies if you know what asbestos is already, but I think it's always useful just to highlight some of the nuances of the actual fibre types. So quite often we'll have clients who come to us with obviously various conditions caused by this substance, and they'll refer to colours. So they'll talk about, I was working with blue asbestos or white asbestos, brown asbestos, and that's actually to do with the fibre itself. So the ones that we'll mainly deal with are the top three there. You've got chrysotile, amosite and chrysodilite. So of the three fibre types there, you can lump them into two different groups. You've got chrysotile, which is known as a serpentine, and that's to do with the curved shape of the fibre and the fact it's a little bit more flexible. And then you have the other two, which are regarded as amphibole, and they are more needle-like structures, and sadly can be more potent in terms of harm and the risks associated of developing one of the malignant conditions. So in terms of the fibre types, we deal with those top three there, and you find often that chrysotile itself was used in more manipulated products that required to be flexible, like fire blankets and corrugated asbestos sheeting, and the other two tended to be more in the older, lagging insulation, people on shipyards using harder asbestos sheetings for various insulation purposes. And on that point, actually, just to give you an illustration of where you can find asbestos, if your home is of a particular vintage, then you might have had to deal with this if you've ever done some DIY, because it was used for a massively wide variety of purposes, from decorative in terms of arctics on ceilings, to fireproofing behind boilers and cupboards, or behind cookers, fireplaces, to soffits on the outside of houses. It was used for so many different reasons, and sadly, not only in domestic premises, but in commercial premises, and very infamously in schools and hospitals. And you'll probably heard about asbestos in schools campaigns and hospitals. Those will continue on, and sadly, the type of clients that we've met over the years has evolved from traditionally shipyard workers through to tradesmen, and now we have cases one, in fact, Euan will touch upon shortly, for nurses, school teachers, all these various occupations that you wouldn't normally think would come into contact with asbestos. And sadly, exposure to asbestos does result in a number of different conditions. And I've tried to lump these into two different groups, malignant and non-malignant, but they can also be categorized as divisible and non-divisible. And what I mean by that is, with divisible, we have to pursue all of the, well, more often negligent employers that the sufferer was employed with and exposed to asbestos, in order to recover full damages. The only exception to that is mesothelioma, and that is an exception to the general rule, and it's treated as an indivisible condition, and I'll come on to that in a quick second. So in terms of the non-malignant conditions, the first one I'll start off with is pleural plaques. That is, by and large, the bulk of the cases that we see coming through, because they can be caused by a very low level of exposure. They are symptomless scarring on the exterior of the lung, so quite often they're picked up incidentally if a client has gone for a X-ray or CT scan, chest infection, or perhaps some other health concern that's affecting them. And then the doctors will normally ask, have you worked with asbestos? We can see pleural plaques on the scans. And then hopefully, if that doctor or consultant is clued in, then they will pass that individual on to a charity like Dianne runs, and then they will hopefully pass them to ourselves, and we can look at civil claim. So that pleural plaques compensatable in Scotland, not compensatable in England or Wales currently, and helpfully thanks to the case of Rotherwell back in 2005, but helpfully the Scottish Government legislated in 2009 to make sure that pleural plaques was a condition that you can seek damages for in Scotland. Moving on to conditions that are not malignant but do actually have a restriction on an individual's breathing, we've got asbestosis and pleural thickening. Asbestosis is the infamous condition that a lot of people will have heard of over the years, they'll talk about, and it's one of the more tricky ones to establish in terms of a civil claim. Quite often we'll see clients who go to hospital, breathing problem, they've got pleural plaques. Very quickly, doctors will label it as asbestosis, but it's not as simple as that. With that condition, we have to show a very, very heavy occupational exposure history, because there are thresholds that we have to go over for us to be able, and the experts that we instruct to be able to label fibrosis in the lung as asbestosis. In fact, the same criteria applies to asbestos-related lung cancer, and it's a diagnostic criteria known as the Helsinki criteria, and that's what the physicians will refer to in terms of saying, is this asbestosis, is this an asbestos-related lung cancer? So it's a condition which is becoming more and more tricky to establish, because traditionally, as I say, requires very heavy exposures, so you usually find it's laggers and shipyards and things, and sadly a lot of those chaps have passed away. So becoming ever more complicated to establish. It's slowly progressing, but can have quite a severe impact on someone's ability to breathe. The same goes for pleural thickening in terms of a restriction on breathing. It's something that can progress through time. It's a thickening on the lining of the lung, and it's actually one of those conditions that can develop to quite a high extent. Asbestosis is slow progression. Pleural thickening can be a little bit quicker, and we've actually had cases where we've been able to establish that the level of breathing restriction has been so significant that it has played a material role in someone's death, and because of that we are then able to open up claims for the family for the loss that they've suffered. So complicated conditions. There's no known lower threshold for pleural thickening, so we are able to establish that a little bit easier in the background of asbestos exposure, and particularly if there's pleural plaques present there, which helps form a bedrock to say there's 100% been exposure here. Moving on to the malignant conditions, I mentioned mesothelioma is slightly different in terms of all the various conditions because it's treated as an indivisible condition. And that is because it is not possible to say for certain which period of exposure caused the mesothelioma to develop. And there was an infamous case called Fairchild, which then led to Compensation Act of 2006, which essentially enshrined in law that you only have to pursue one negligent employer in order to recover in full, which does help simplify the process in one aspect. However, we still have a lot of challenges in terms of causation and liability, which Euan's going to touch upon in a quick second. So mesothelioma is sadly a very aggressive condition. It sadly is a terminal diagnosis, but there are improving treatment options. Previously, when I started this job, all that was available was radiotherapy and chemotherapy if someone was fit enough for that, and it was mixed success. Sometimes clients would respond well to chemotherapy, other times it did nothing, and sadly they had to suffer the horrible side effects of chemotherapy. But immunotherapy is now available on the NHS, and that has proven to prolong the life expectancy of meso sufferers. So that hopefully will continue to develop and hopefully extend their life expectancy. Because the diagnosis is sadly terminal, the Damages Scotland Act 2011 makes an exception for mesothelioma cases, where if the live case, if we're able to settle that, hopefully we are, especially in the client's lifetime, there is an exception within the Act for meso cases that then triggers family cases upon their passing. So we can then pursue cases for the deceased's spouse, children, grandchildren, and their siblings as well, and parents if they are still alive, which is quite very, very rare, but if they are. So all of those cases combined can mean that all adds up to a very, very significant value. And I'll come back to that in a quick second when I come to time bar. The last condition is asbestos-related lung cancer, and I would probably say it's up there with the more complex cases to establish. The reason being is that it is divisible, so we have to try and pursue everyone involved in the case, so the former employers or the insurers. We have to get over a hurdle of a very high occupational exposure history in order to satisfy causation. And quite often, defenders will get reports to try and chop away at everything that we built up in a case. So we'll get expert engineers to come in and say that someone's been exposed to X level of asbestos, which is quite high. And as you can imagine, they'll come in with an expert that says the exposure levels over the lifetime are very, very low. And if you fail to meet that threshold criteria, then we fail to establish that it's an asbestos-related lung cancer. As you know, people can develop lung cancer because of a smoking history. If someone's a smoker, it doesn't prevent us from pursuing a case. Smoking and asbestos within the lung have a really horrible synergy where they will interact and multiply the risk of a cancer developing. So it doesn't prevent us from pursuing an asbestos-related lung cancer case, but what does happen is it comes back into play in terms of contributing negligence. So sadly, if we are able to establish the case, there is usually a percentage deduction to reflect the fact that they have been a smoker. So it is one of the more complicated conditions to diagnose and establish a case for. And underpinning all of these conditions is something that we always have to be on our toes about, and that is time bar. So time bar is something I've had to deal with, well, we deal with in every single case, but very, very recently we had a case on this point, and I will talk about it in a quick second. So most of you will know, you've heard it on TV and radio, the 3-year period you've got to pursue a personal injury case. And that's the same for asbestos litigation. You get 3 years, and that 3-year time limit begins from the day in which someone has been advised they have an asbestos-related condition that they can pursue a case for sounding and damages. Now, we do have cases where that's straightforward and someone has been told and they've been advised, perhaps given a leaflet for a charity like Dianne's, and they're then signposted and everything then follows on perfectly. That's absolutely fine. However, sometimes it's a little bit more vague. It's a bit ambiguous as to what they were told, when they were told, what can they do, were they given the proper advice. So we'll quite often refer to 17(2)(b) of the 1973 Act and try and establish the date on which they were able to link that diagnosis being sufficiently serious to link it to their occupational history and a particular period of employment with employer, and then we can try and use that date depending on how the case looks. And it's something that we will get arguments about in many, many cases if there are pre-existing x-rays or CT scans where things have been picked up but perhaps not communicated. It's something that can happen quite a lot in these cases. In terms of the family cases that I mentioned earlier that are triggered when one of these conditions prove to be fatal, the family have 3 years from date of death of the sufferer. The reason that I'm highlighting time bar here is because we are stuck with a principle currently called one action, one harm. And that was sadly enshrined in a case called Aitchison, which is a child abuse case, and you're relieved to hear it. I won't go into details of that, but essentially what the Lord President said in that case is that there will be no new limitation period per diagnosis. So someone has been exposed to asbestos, and because of that period of exposure, they are at risk of developing a number of different asbestos conditions. When you are first told about the first diagnosis, whatever that may be, you have 3 years. If you do not pursue legal action in respect of that exposure within that 3-year period, that claim will time bar. However, because of this principle that we're stuck with, it also time bars any subsequent diagnosis as well. And that's obviously quite bad because if you have, for example, someone who's diagnosed with pleural plaques, which is an asymptomatic condition, if they fail to pursue a case within that 3-year period, not only does the plaques case time bar, but also would time bar the diagnosis of mesothelioma. And the knock-on effect of that as well is the family cases would also be time barred. And that's why I refer to Section 4 here, because within Section 4, it basically says, yes, if someone has mesothelioma, the family will then be entitled to receive awards of damages. However, that's subject to virtue of an enactment. So if you go back to the time bar situation under the 1973 Act, if you've time barred your first diagnosis, everything else is time barred thereafter. And very recently, as I mentioned earlier, I had to try and argue this point in a case of one of my clients, Mr. Smith. Mr. Smith, we went to proof. It was a preliminary proof on time bar in February, and I suppose that the headline is that we lost. And it was a decision that we lost, but certainly I think it's an important decision to highlight here, as much as it's not fun highlighting losses. In terms of a quick background, Mr. Smith was employed by Hull Russell Shipyard, as pictured there, in the late 60s, early 70s as a joiner. He was working on board ships, cutting asbestos sheeting. The merits of the case on liability, quite straightforward for what we do. He was diagnosed with pleural plaques on 5th of June 2019, and then was signposted to a charity. He very responsibly and quickly contacted the charity, who then put him in touch with Lefevers. I can name the firm because they're mentioned throughout the judgment. Lefevers intimated the claim, but sadly didn't raise proceedings within 3 years, and then it time barred. Mr. Smith contacted me in July 2022, having no idea about the time bar situation, and asked if I could have a look at the file. I had a sneaky suspicion that it was time barred, got the file over from Lefevers, and sadly I was correct. It was time barred, and I had a discussion with him before I told him that it was time barred about provisional and full and final. So when someone is diagnosed with essentially anything with malignant conditions, we can seek full and final or provisional damages. And with provisional damages, you obtain an award of damages for the diagnosis, but you also secure the ability to come back in the future should you go on to develop one of the other conditions. Because the case was time barred, we were looking at either a professional negligence claim against Lefevers, or looking to try and pursue a personal injury claim with a Section 19A argument to allow the court to allow the action to proceed in any event on the balance of what is just and equitable. And Mr. Smith was very clear that he wanted provisional damages. We tried it because we thought we had a good argument here, in the fact that there is a gap here with professional negligence damages. You cannot obtain an award for provisional damages. All you can do is get an award to reflect your loss opportunity, etc., for a full and final Platts case. So we tried the 19A argument in court. We highlighted that it was a shipyard case. The shipyard was bust. Essentially, there was a a government scheme in the background paying out the damages. There was really no prejudice whatsoever to them, but sadly Mr. Smith had lost the right to come back for mesothelioma and also his family as well. And the case was dismissed because the judge did not find favour with our argument. Sadly, he attached too much weight, in my view, to the right of relief against Lefevre's, not enough weight to the fact that there is potentially a lot of value in a provisional damages interlocutor, which not only could the pursuer benefit from significantly, but also his family. So sadly, the case was dismissed, and we are now pursuing the professional negligence claim, which is going to be very straightforward. If you ever read the judgment, you'll see why. So it's a loss. It's not great to talk about your losses, but I think it's a really important one to highlight, just to illustrate the fact that you have to be on your toes when you're diagnosed with a condition, how you then respond to that, the action that you take, and to litigate quickly and also receive proper advice about what your options are. So that rounds off my topics. I'll pass you back to Euan to go on to the next set of challenges that we face.
That's great, Gary. Thanks very much. I thought I would just highlight some of the challenges that we face, both in terms of arguments put forward by defenders, agents, and how that impacts us in practice during the course of a case, and then also the continual battles we have in terms of the law not being in quite the right place and where we need to try and effect legislative change. So the first thing I wanted to mention was these low exposure cases. As Gary said, the nature of the cases that we are pursuing has changed over time. They used to be more straightforward in terms of heavy industry with shipyards, where liability and medical causation, proving a link between the asbestos exposure and the condition, mesothelioma usually in these cases I'm talking about, was fairly straightforward. And it does remain the case for most of our clients that it is reasonably straightforward in the mesothelioma cases, the more serious cases. The majority of our clients now are tradesmen, so joiners, plumbers, electricians, the people that were putting the asbestos into the buildings during the huge building boom in the 60s and 70s. So that's the majority of our clients are tradesmen. But where we're seeing issues is the people who are working, teaching, living in the buildings that these men, as it was, put up. And that's where we're seeing the low exposure cases, where we're scratching our head a little bit in terms of trying to identify where the exposure was. So there's a line below which is difficult to take on a case. If someone can't identify any exposure to asbestos, sometimes we can't take it on. But other cases are more challenging, and we will try our very best with them. And this one that I want to talk about is an example of that. And this is a chemistry teacher. I can mention her name. There's a decision with her name in it that was given last year. So Sarah Kerr was a chemistry teacher, and she worked for Midlothian Council and Murray Council. So she worked both in Elgin and Dalkeith as a chemistry teacher. And she was diagnosed with peritoneal mesothelioma. So mesothelioma is primarily of the lung, the lining of the lung, a very aggressive cancer, but can also be found in other areas of the body, and hers was the peritoneum, which is the stomach. So she had quite an aggressive form of this cancer, unfortunately, and didn't live long enough to see out the case. But the issue with her case was that the exposure to asbestos was not terribly heavy. She was handing out Bunsen burner mats, and we know from previous cases that Bunsen burner mats contain asbestos. Not huge amounts of asbestos, but she was giving clear accounts of handing out these asbestos Bunsen burner mats, which I can certainly remember, and a lot of people that you speak to remember, these being handed out in both science classes and chemistry classes for experiments to protect the wooden worktops, but these old mats. And she described dust when she was putting them away. They were frayed, they were broken. So there was definitely a case there we looked into and decided to pursue. The issue of breach of duty, so whether or not the local authorities were negligent, it was never admitted, but it wasn't really seriously contested. And one of the reasons is on this slide. So this was from St David's High School in Dalkeith, and this is a freedom of information request that we did for asbestos surveys. And this latest one was done, I think, 2020. So every school, they have external people coming in to do asbestos surveys. This one only happened, in fact, in response to her diagnosis. So the union reps kicked off, as they should. The council then asked an external company to come in and do an asbestos survey. So they checked the fabric of the building, but they also, in this case, unusually checked the asbestos, the Bunsen burner mats. And they found that some of these contained asbestos. So that was in 2020, or maybe a couple of years after. So there's no doubt that it was still there. And I suspect that is repeated across Scotland. There's been no uniform removal of asbestos Bunsen burner mats at all in Scotland. So the issue of breach of duty wasn't really seriously contested. And that's what we find. The battleground in the mesothelioma cases changes over time. It has been breach of duty, proving fault on the part of the employer. That's been a huge issue, huge battleground, and it does remain a battleground. But the biggest issue for us now is this medical causation. And that's where we're coming up against really quite sophisticated arguments in more recent times, and they're becoming more sophisticated that we have to fight against. So the test for causation in mesothelioma cases is a bit unusual. It's not the same as the but-for test that you have in your usual accident case, where but for the injury, but for the accident, this injury would not have developed. We cannot say scientifically, we cannot say that a given exposure to asbestos caused this mesothelioma, because it's scientifically not possible to link it to a specific episode. So the courts bent the rules a bit. So in the case Fairchild against Glenhaven, a really helpful case where the court bent the rules specifically to allow mesothelioma cases to be successful. So what we have to do is show that the negligent exposure to asbestos materially increased the risk that the individual had of developing mesothelioma. So really, that's one of the most important decisions that we've had in mesothelioma litigation, and that was back in the early 2000s. So a really helpful decision that paved the way for us to win a lot of cases we otherwise would not have. But as the low exposure cases are becoming more common, the arguments are becoming more sophisticated. And what they're now arguing, or putting us to proof on, is proving that the exposure that we are litigating in relation to, so in this case, the Bunsen burner mats, that exposure in its cumulative calculation materially increased the individual's risk. And what they're doing is comparing that to any individual's risk of mesothelioma, given the environmental exposure to asbestos. So a lot of people don't appreciate that asbestos is everywhere in the air. So we all walk around breathing in asbestos. It's indoors, it's outdoors. So what they got an engineer to do in this case, and it's the first time I'd seen this approach, and it caused real difficulty, was to try and calculate Sarah Kerr's cumulative exposure to asbestos. She died very sadly. She just retired. She was 65, developed the condition and died soon after. So they were calculating what was her cumulative exposure to asbestos during her lifetime, the environmental exposure. And you can see I've copied the table that was in the defender's report here, showing that the number of fibres of asbestos per milliliter in the air, both outdoor, residential, in schools. So they do their calculations a bit like smoking pack year. So they calculate your cumulative dose of exposure to asbestos. So this is the first time we've ever seen this approach. So they calculate it as 0.046 fibre mil years, but it's a technical calculation. But what then that is compared to your workplace exposure. And if your workplace exposure is de minimis in comparison to your environmental exposure, they will argue to the court that the exposure at work was not enough to materially increase the risk, that it was de minimis and it can be disregarded. And this was never the approach previously. If we had a given exposure to asbestos, even a day or two above background levels, that would have been enough for the court to say it's materially increased the risk. But the defenders are becoming far more sophisticated, and the cases are now really expensive, really complicated to run. We've got reports from experts coming out of our ears, from medical experts to engineers to statisticians, epidemiologists, arguing about the efficacy of all the data that's being used, because these figures of cumulative exposure are then plugged into other data to try and convert that into an individual risk from a given exposure as compared to your environmental exposure. So they're really complicated, challenging cases for us to run at the moment. In this case, unfortunately, we were unsuccessful. It came down to a battle between two sets of experts, and the defenders' experts were preferred. It was a low exposure case, and we're trying to figure out how to find a way around these arguments, but it's dependent on getting the correct experts in the courtroom to persuade the judge in this case that the exposure isn't something that should be dismissed or disregarded. But these are really tricky cases, and we're seeing a few more of them. But I say the majority of these cases were still able to be successful, but this is the area that's been really looked at, and it's one that we have to focus on, and it definitely keeps us on our toes. And that's always been the way with asbestos litigation in terms of personal injury. There's probably no other area where there's been as many battles, both in terms of getting the courts to change their approach, and also in terms of asking those legislating to make changes to the law. And I'll just quickly touch on two areas that we are working on just now to try and address. And Gary touched on the issue of time bar, where a mesothelioma case can be time barred by an earlier diagnosis of pleural plaques. And the leading case in this is Quinn against Rights Insulation, where an individual was diagnosed with mesothelioma, but it was clear from their medical records that about 6 or 7 years prior, they'd been diagnosed with pleural plaques and signposted by the doctor to a charity, such as Asbestos Action, to seek advice. They didn't do anything about it. So they were asking the court to apply discretion in terms of Section 19A of the Prescription and Limitation Act 73 to set aside the usual time limits and say, give the guy a break. He had a diagnosis many years ago of a non-malignant condition, a condition that causes no symptoms at all, and that's barring a fatal condition. But the court refused to exercise that discretion because of the one action, one harm rule. So I think that the injustice in that is pretty clear, and that a condition causing no symptoms can time bar a subsequent fatal condition. So the Scottish Law Commission have been looking at this, and we've been providing input as a firm as to what potential solutions there are to this issue. And at the tail end of last year, they produced a report on the damages for personal injury. And in a section of that, it addresses various issues, but one of the sections it addresses is this issue of pleural plaques cases, time barring mesothelioma cases. So what they want to do for a mesothelioma case is disregard the earlier diagnosis of plaques when calculating the time bar. So that a bill has been drafted and is now working its way into the Scottish Parliament. Whether or not there will be time before the election next year to implement it, we don't know, but it's on the radar. And the way it's drafted is quite helpful. There are almost retrospective elements to it. If we can get it passed through rather than later, it will help us, because we have had to close about 3 or 4 cases, mesothelioma cases, because of the way the law stands at the moment. So that's one battleground that we're trying to change through the Westminster and Holyrood. That one is Holyrood. The next one is Westminster. Gary touched on asbestos-related lung cancer. There are many ways that people diagnosed with asbestos-related lung cancer are in a weaker position than those diagnosed with mesothelioma. Mesothelioma has been the one that's had the big focus on it, and that's the one that's had the law changed to help those sufferers. Asbestos-related lung cancer wasn't really pursued in big numbers previously, even though there should be a ratio of 1-to-1 cases. That's according to the Health and Safety Executive. So it's been ignored a bit. And then one of the issues is that with a mesothelioma case, you can sue one employer and receive 100% of your compensation, and that's due to the Compensation Act 2006, Section 2. So the Association of Personal Injury Lawyers is working with politicians to try and get that amended so that lung cancer, asbestos-related lung cancer sufferers are put in the same position, so they can sue one employer, because it really delays us hugely in terms of investigations for a lung cancer case, and they may only get a proportion of their damages, unlike the mesothelioma cases. So in terms of Scotland, Marie McNair in the MSP for Western Berkshire is doing great work in relation to the initial issue of time-barred plaques cases. Douglas McAllister doing great work in relation to this at Westminster. And one of the great links that we have, and I'll introduce you to Dianne to talk a bit more about the charities, is that the whole community of people involved in helping people with asbestos-related disease work together really closely. So the doctors, the politicians, the lawyers, the charities, and I say the charities are really the centre of that we can speak about issues and get issues resolved where possible. And the charities play a crucial role in that. So these are just some of the issues that we're facing at the moment. But what I'd like to do is pass it on to Dianne from Asbestos Action, who will talk to you a bit about the great work that the charity does. And I'm sure at the end, if you have any questions, you can ask any of us those. But yeah, I'll pass it over to you, Dianne.
I think you're on mute, Dianne.
There we go. Sorry about that. Good morning, everybody. Thanks for this opportunity to share my passion on the charity that I manage. Asbestos Action, to keep you being you. That's our strapline, and that's really what we follow throughout everything we do to support clients who are diagnosed with asbestos-related conditions. The key thing is that sadly most of these people will be debilitated in some way because of the condition they've been diagnosed with. And as a charity, we're here to try and help and support them and guide them to have the best quality of life they can for as long as they can. And sadly, a number of them, as Euan and Gary have explained, their life is very, very limited. But even so, as a charity, we believe that, there's still quality in that life. And part of our role is to make sure that that happens. Thanks, Gary. Okay, so who are we? Asbestos Action's been around now. We're in our 23rd year. Again, I'm not going to read to the text, so please, by all means, have a read. We've been around 23 years. We were set up by sufferers. They themselves got together and decided that, we need to support each other. There are people out there, further afield that actually don't have support, don't know what help's available, and perhaps we need to get that up and running. That's how it started, and we had some support from a wonderful nurse known as Nancy Rattray, who came on as an advice advocate, I think, but she then became one of our directors and stayed with us for 21 years while we went through the process of becoming a registered charity. We're obviously governed by Companies House and Oscar to make sure that we, follow exceptional guidelines and making sure that we're doing the best we can for our clients. Thanks, Gary. So who are we? So basically the charity is made up of a board of directors and charity trustees, and basically they are responsible for the governance of the charity. Myself, my role as general manager is to be responsible for the operational running of the charity and to feed back into the directors and look at, progression and support for our clients. We're a small team. When you look at the numbers, but I think we really, really do, in the words of a previous colleague, we punch above our weight. I think we work very, very hard, and we're all very individually passionate about what we do. And I think the most important thing is our clients and making sure that they get the best service that we can possibly offer them. Thank you. Okay, we have a number of referral routes. Now, the important thing is that we help with the compensation side a lot, in the sense that from our point of view, we have a duty of care to pass that information on to clients. Quite often what will happen is when people are diagnosed in hospital, for example, it may be touched on by their medical professionals, you may be compensated or you may be eligible for compensation. But that is really not the right time to have that conversation directly, because people have just been told quite often that they've got a terminal condition. So our job is very, very important, in that when we then link in with our clients, that we sit down with them in their own homes, we go through how they're feeling, we support them, and as part of that process, we have a duty of care to talk to them about their eligibility for potential compensation. We're not lawyers, we don't pretend to be, and we certainly don't take on that role. People like Digby Brown are the professionals. They're the ones who know asbestos cases inside out. We don't. We know the peripheries, but the important thing is that we get our clients the best quality of service, and the way to do that is to make sure that we refer on to Digby Brown to make sure that they get that information, and then the client can decide at that point if they then want to pursue a claim. The referrals, like I say, can come from very many different directions. We can get through phone calls, people pick up the phone. It could be somebody that's spoken to a friend that, who they've said, oh yeah, I was diagnosed with this. And somebody goes, oh, have you been in touch with Asbestos Action? No, who are they? It could be more professional, like I say, it can be the referrals coming through hospitals, consultants, the mesothelioma nurses, for example. We've got a huge number of GP referrals. That tends to be for the lesser conditions, pleural plaques, pleural thickening and asbestosis. And we also get third-party referrals. So again, Digby Brown may contact us saying, look, we've had somebody contact us directly, but they actually haven't got any support from a charity at the moment, and they've asked, can we pass the details on to you, and we will obviously contact them. Thanks, Gary. How we help our clients. This is only part of what we do. It's very hard to put into words what we do. You know, when you're actually going into someone's home who's just been diagnosed with mesothelioma 2, 3, 4 days before that, you can imagine it's a sledgehammer moment. You know, they're sitting there, they're in total shock. They don't know what's happening. They don't really understand their condition at that point, other than they've been told they've got a terminal condition. A number of people with mesothelioma can actually be pretty well before their diagnosis, just so that, you know, to go with I've been a wee bit breathless for a little while, I've got a wee bit pain in my back, to suddenly be told, well, actually, you've got a condition which may actually limit your life to a few months, is a huge shock. So it's very, very important that we are there to support at a very early stage, but also to offer hope that actually life is still worth living and that life continues even with these conditions. We do a huge number of things, and one of the services that I'm really very proud of, and again there was some support through the charity manager at Digby Brown to assist us with this, and that was offering a free will service. So, you know, there was a bit of an assistance for me to how do I go about it? You know, how do I find other lawyers who might be able to assist us with this? And for our clients to be able to be offered a free will service is extremely important, because, you know, the financial reduction can be huge for some of these clients. We are suddenly having to give up work if they're still of working age, if they're of pension age. You know, there's a huge financial impact when they're looking at, you know, having to travel for treatments, etc. Their heating's suddenly on, you know, 24 hours a day because they're very cold and, you know, they're unwell. So, you know, to be able to get a free service is extremely important to us. Okay, thank you. We obviously hugely support our clients, and our clients are at the centre of everything we do. And we're very much a person-centred service. So our clients we'll be guided by our clients as to what they want from us. So there's no one service fits all. It's very much individually led, and we'll tailor the service to the needs of our clients. But the other side of what we do includes a number of other things, and that includes events and awareness raising. Obviously, Euan's spoken about, you know, the fact that we will highlight issues and campaigns that they're concerned about as well, and we will hugely support those. I've given a couple of examples here of some of the things that we've done. This is just an extremely small snapshot of things that we do, but we continually are raising awareness all over the east of Scotland, which is the area that we cover. Having said that, you know, when people do contact us from other areas, if there isn't a charity available in their area, we will support them. You know, we don't draw a line and say, oh, no, sorry, you're not in our area. If we can't get a local charity to support them, then we will continue to support them, even if it's at a distance. Okay. Networking is another huge thing that we do. We have a lot of partnership and working in collaboration with a huge number of different services for our clients. We do a lot of self-referrals. We do making sure that they're signposted to other organisations who can assist and support with more specialist services, including things like mental health. We work closely with other organisations that are up and running. A big example for that is in Fife, is the Breathe Easy group. You know, why would we set up a support group when there is an absolutely amazing service there already in 5 different locations in Fife? So we collaborate very, very closely with them to ensure that our clients have access to their service as well as ours. We work alongside other groups and services because it creates a stronger voice. And that then offers an exceptional service to our clients rather than just a mediocre one. Thank you. Campaigning is key. As Euan's alluded to, there are so many things that are still out there that we need to campaign for this group of people. And we feel very, very strongly about that. And so we are part of a member of the Asbestos Victim Support Groups Forum, which is a UK-wide forum. So we have a much stronger voice when we can talk together and strengthen numbers, and we can challenge and we can lobby in both the Westminster government and the Scottish government in relation to, you know, improving the situation for asbestos sufferers. CAPE campaign, I'm not going to go into, but it was led by the Asbestos Forum, and they actually were instrumental in taking it to court. I would encourage you to have a read about it. It's a very interesting read. We again have always been continuing to ask about removal of asbestos in schools, not only schools, but hospitals and public buildings. And again, we are continuing to campaign about a planned removal of asbestos in Scotland, and that is ongoing. We will often raise and attend the Scottish Parliament for debates on asbestos-related issues, being supported by particular Scottish MSPs who can raise these debates for us, and then we can go along and support the debate on the day. Okay. And finally, I think, the most important thing for us is that our ethos is that our clients should be offered the best possible service. So my attitude is, what would I want if it was a member of my family? What is the type of service? I would want people to go above and beyond the norm. And I think that's what our team does. And I'm very, very proud, having been with the charity for 11 years, that we do that and we will continue to do that. What's also important, though, is that when we are making referrals over to Digby Brown, I have to be confident that it's not, sorry for saying this, but it's not just we've referred to a lawyer. We want somebody, or we want a company that's more than just a lawyer. We need people who understand what our clients are going through, understand the day-to-day impact that these conditions are having, both physically and emotionally. So, I've taken time, and Digby Brown have been extremely encouraging of this, that every time we've brought on new members of staff, everybody gets to meet every one of the team at the industrial disease team at Digby Brown, so that they can meet them in person, they can be comfortable and reassured that they would have no issues with these people going into our clients' houses, that they have complete understanding and empathy for our clients, but more importantly, that they'll give our clients the time to understand what the legal process is. So they're not rushed into anything. They have time to think about it. There's not forms taken out to house visits to be signed, on the dotted line. They will be sent out to them separately, so they have time to discuss it either with their families, with us, and then they will sign at a time that suits them. And they then, at that point, completely understand the process. And that is so important to us. I think from my point of view as a manager, I'd like to thank Digby Brown, because I think they do understand fully what we're about as a charity. We work in conjunction with Digby Brown, but our clients come first, and they are a priority. And I think Digby Brown do completely understand that, which is why, I was more than happy to be involved in today's webinar. So thank you very much.
Perfect. Thank you for that, Dianne. Really appreciate you taking the time today. Thank you to Gary and Euan as well.